burglary, probation, and a courtroom on edge, this is no ordinary case. Joshua Mays is facing serious consequences for violating the very probation that gave him a second chance. Today, the judge hears it all. Excuses, missing programs, GED struggles, and alleged lies. The question is, has Mays truly failed, or has the system failed him too? Stick around, because the final verdict is not what you'd expect.
All right, so you're Joshua Mays, and Mr. Mays is on probation for burglary of a habitation, was placed on a deferred probation.
Let's clarify this. Mays was placed on a 3-year deferred probation. That's basically a legal warning. Behave or face the full force of a conviction. But the moment someone files a motion to adjudicate, it means Mays has likely violated the terms. When he admits he failed to report and didn't pay court fees, that's not just a slip-up. That's an official, on-record violation.
Back in September of 2021, and that was a 10-year, no, it wasn't, it was a 3-year deferred probation. There was a motion to adjudicate filed. We were here before. Mr. Mays pled true to failure to report and failure to pay court-assessed fees. Let's see, hold on a second, let me go back and find what the other counts were. So it looks like, do you want to put on any evidence with regard to counts 2 and 3, the education program and the MRT?
Yes, I do, Your Honor.
All right, you can call your first witness, Mr. Nichols.
You swear to me?
Yes, would you please raise your right hand, ma'am? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you.
Ms. Joseph, how long have you been supervising Mr. Mays?
Since April of 2022.
And during that time, was he...
This part is telling. Mays had a chance to better himself through education and therapy, and he didn't follow through. His probation officer says he never even started the GED or MRT programs. Yet Mays still argues he made progress. With no paperwork, no attendance, and no verification. Are we seeing progress or just another excuse?
Ordered to participate in the GED program.
Yes.
Has he completed that?
No, sir.
Did he provide you the verification that he was participating in that?
No, sir.
Are you aware of the issue he outlined in the letter to the court that he claimed he made progress while at ISF, but those credits would be accepted by the program? Or do you know what that issue is?
I read it in his letter.
Do you know anything else about that, whether or not they would take those credits or not?
Here's a twist. The MRT class was temporarily suspended due to staffing issues. So we ask, was Mays lazy or was the system unavailable? But here's where it gets serious. Despite the pause, Mays didn't pursue alternatives or even communicate. Viewers, tell us in the comments, should probationers be given a pass when systems fail, or is personal responsibility always the bottom line?
Yeah, but did he give you the verification that he's been participating in that GED program? Okay. And moving on, was he also ordered to participate in the moral recognition therapy program?
Yes, sir.
And has he participated in that?
No, sir.
What level of participation has he done in the MRT program?
He has not even begun to start it. However, while we were waiting to come to court for this, they have since discontinued for a period of time until they can hire someone to offer the class, and we will again, but it's just worthwhile to note that while we were waiting, somebody retired, and so they had to hire someone else.
At what point did they suspend the MRT program?
March of this year,
Okay.
March or April.
But during the years he's been on probation, he had not made
Prior
any
to
progress.
that, no, sir.
Okay. And so should he be, that program you believe will be available in the future?
It will.
Is there anything else contained in your pre-sentence investigation you want to bring to the court's attention?
Maybe what I need to say.
Okay, thank you. Now I'll pass the witness, Your Honor.
Thank you, ma'am. Mr. Kimler?
Have you checked with the ISF facility to see if they have a GED program, or
They for a fact do, sir.
did you check to see if he participated in it? Did you check to see if he participated in it?
He didn't mention anything about it until after his release from the facility.
And my question is, did you try to
No, I
check?
didn't have a reason to, Mr. Kimber. He didn't say that he had participated.
This moment is jaw-dropping. Mays was marked as an absconder, not once, not twice, but 3 times. That means he completely vanished from supervision. In legal terms, it's one of the most serious probation violations. You can miss a class, maybe a meeting, but disappearing? That's walking the line between probation and prison.
In that until after his release.
No, I'm not trying to put you in a defensive posture. I'm just wondering if there's been any kind of independent attempt by the probation department to corroborate what he said about participating in the program while at ISF.
He didn't present any documentation.
So my
And I
question-
didn't check with ISF to verify what he said.
But just to be clear, ISF does in fact have a GED program.
They do.
Okay. Has he maintained employment while he's been on probation?
He has.
So lack of a GED, and again, the GED's worthwhile on its own merits, but it doesn't seem to have impacted his ability to maintain employment, the lack of the GED. He's been able to maintain employment without a
He has.
GED. So you would say he has worked faithfully at suitable employment?
He has.
What is the moral recognition class? Is that how you say it, recognition?
Yes, sir. That's how you say it.
How many sessions is that?
8.
Over a week, once a week, or once a
They
month?
present one lesson each week until they have finished the course.
And it's a progression, then they're different classes. It's like a progression of 1 through 8.
There
So you
is
would
a
have to-
book that they have to purchase, and they do each chapter in the book until they have completed the book.
In sequence, right?
Yes,
In
sir.
sequence. So he would need at least 8 weeks to complete that if he took 1 session per week, is that right?
Yes, sir.
Has he maintained the proper demeanor with you?
Yes, sir.
And as far as his reporting, he certainly hasn't become an absconder, is that right?
He's
He
been an
has
absconder 3
before.
times.
Well, as far as what she's concerned, has he maintained contact with you, or has he become an
Since his
absconder?
release from custody, yes.
He's maintained contact
Yes.
with you and reported this directly.
Yes.
In your report, you seem to indicate a willingness, a reluctance.
This scene is awkward and powerful. The probation officer won't recommend keeping Mays on probation, but also won't recommend revoking it. That's a total pass-the-buck moment. And it puts the full pressure on the judge. What would you do when even the expert can't decide?
Willingness, perhaps, to have him continued on probation. Would you agree with that?
I hesitated to recommend that he be continued.
Did you recommend that or not?
My statement was that I hesitate to recommend, should the court decide. So I'm really leaving it up to the court, because I don't want to make a recommendation.
Because you don't have a recommendation. So you're not recommending that he be revoked, but you're not recommending that he be continued. Is that fair? But if the court were to see fit to continue him, then you would suggest extending him a year to give him an opportunity to complete the GED, pay his fees, and I guess at this point, once you all get somebody hired to do the moral recognition therapy class. Is that right?
Right, and I also recommend he come back to verify.
Every 6 months?
Yes,
Sure.
because he has a habit of not reporting.
And of course, you could notify the court in that event. We could schedule a hearing and holding this in advance, right? These allegations.
I'm not
Yes.
holding, yeah. Okay, go ahead.
I was just, if that's what,
Yeah.
what's the purpose of the moral recognition therapy class? What's that directed to achieve with the probationers?
It's to teach them moral standards, have a sense of ethics and values, as well as other life skills.
To what end? To keep them from reoffending, would you agree?
Yes, sir.
Be a good citizen.
Yes, sir.
Has he reoffended since he's been on probation? You know?
No, well, no, sir, he has not.
That's what.
I have no other questions concerning those allegations, Your Honor.
Thank you. So concerning those allegations, number 2 and number 3, I am going to find those true.
Here's where it all becomes real. The judge finds counts 2 and 3 true, officially confirming that Mays failed to follow probation terms. It's no longer just an allegation. It's a documented violation. And with no proof Mays completed required programs, the court has no choice but to move toward punishment. Harsh? Maybe, but fair.
That there's sufficient evidence to find counts 2 and 3 true. And so what the ISF that he went to, it doesn't say if it was cognitive or, do you know, Mr.?
It would have been a combination of both at the time. It was substance abuse cognitive intervention tracks because he tested positive for THC.
So he went, back then you could do both. You can't do that now. I don't think.
Based on what they're offering at this point. But yes, he went for cognitive as well as substance abuse.
Okay.
And we're referring to the admin hearing from January 15th of 25, Your Honor.
Thank you.
Indicates that on January 12th of 2024, that it was recommended and approved that he, or on the 23rd, sorry, that he would successfully complete ISF cognitive and substance abuse tracks.
So is that a 6-month program or a 3-month?
It is a 90-day program.
90, so both static.
I think they changed what they offer now, but it's substance abuse now, and then it's a cognitive, and then relapse at this time. They combined substance abuse and cognitive tracks.
Okay.
I think you wanted to address the court to your at the appropriate time. He has written a letter.
I've read the letter as well. Mr. Mays?
With the transcripts, I have them in my folder. When I went up to the GD, the workforce center, the lady said that she couldn't take them, so I started doing the GD on my own, like on my phone. When I get off work, I complete the classes on my own. I just never brought it to her attention, but I have been doing the different classes and stuff on my own.
Why didn't you bring it to her like you're supposed to?
No excuse.
Okay. Mr. Nichols?
Judge, I know that this is a tough call for the court. These aren't the worst allegations we've ever seen, but he's also in zero tolerance and has been.
Mays finally speaks, and it's a Hail Mary. He says he's been doing GED work on his phone after work, but never told anyone. No paperwork, no updates, no communication. This isn't how probation works. You can't silently succeed. You have to prove it. Why wait until you're standing before a judge to explain?
Several times sanctioned, both in jail and with the ISF programs, and still, after only about 3 years on, not even 4 years on probation, Judge, we're back yet again. It's really a test of zero tolerance at this point, because that's what he was ordered, was no problems whatsoever. And missing 3 months of reporting is a pretty big red flag to me, Judge.
Let me look back at something real quick. Also, before I want to make sure everything is saying that it was burglary of a habitation, but at some point, it looks like, at least on the old PSI, it was attempted burglary of a habitation of 3rd degree. I want to make sure all the administrative hearings, the motion to revoke, everything says burglary of a habitation. I want to get that cleared up.
Your Honor, actually, I think the indictment is attempted. At least I'm looking at the indictment that's captioned attempted burglary of a habitation.
Okay, so the burglary of a habitation, do you want to make an oral motion to amend at least this motion that we're talking about today?
Yes, Your Honor, I will change burglary of habitation to attempted burglary of habitation, comma, a third-degree felony, Mr. Judge.
All right. So we're talking about a third-degree felony. So, Mr. Mays,
This part hits emotionally hard. The judge isn't just frustrated, she's disappointed. She points out Mays only started caring when court was near. That's a pattern in many cases, last-minute effort to avoid punishment. The question is, does late effort deserve a second chance?
the problem is that you just like to do what you want to do when you want to do it.
Yeah, I'm not.
And-
Should I argue first? The thing I just wanted to say is, it's kind of a glass half full, glass half empty thing. If you want to look at somebody that we're trying to return to the community as a productive citizen, which is the goal, versus sending another person to the penitentiary, he has maintained employment. He's had some, I guess, hiccups on probation as far as reporting, but he hasn't reoffended and he's employed. He seems like he is making a positive contribution to society at this stage. I don't really see where the interest, me personally, as the interest of the community would be served is to send another person to the penitentiary where they are making enough progress. And again, it's marginal, but looking at the totality of the circumstances to keep working with him, to hopefully keep him out of prison where you can keep employed.
Well, here's my thoughts, Mr. Mays. You're not going home today. That's not happening. You're not going to walk out of here today. You're either going to get revoked and go to prison, or you're going to go to the cognitive track of ISF. Because somewhere along the path, you did not pay attention and you haven't learned.
Just when it feels like Mays is going to prison, the judge throws a curveball. He gets one last chance, 3 more years of probation, and he must complete the ISF cognitive track. This is no win. It's a loaded second chance with 0 tolerance. One misstep, and it's over. Would you trust him with another shot?
From whatever treatment you've had before to make better decisions. You've been put on 0 tolerance. You've been told don't miss another appointment. You have now 3 different times been given these opportunities and have not taken advantage of them. I don't disagree with Mr. Kimler. You haven't reoffended. You're not testing positive all the time. You're not doing those things, but you don't get to choose when you go to probation, when you don't, and you don't get to all of a sudden be really good at it when you have a court date coming up. Because that's something that is really frustrating to me, is that all of a sudden people start doing what they're supposed to be doing when they know they could go to prison. So my thought, I mean, you think it's ridiculous. You have hardly any criminal history. You got into some trouble as a juvenile. You haven't been in much trouble at all. And you're not taking advantage of keeping this conviction off your record. And that's going to be on you, not on me, if this happens again. Because I have no doubt if I do what I'm thinking about doing and we're back in here again, Mr. Nichols is going to point out to me how many times I've given you an opportunity. Do you understand? There will not be another opportunity. I'm going to find that you entered your pleas of true to counts 1 and 4 freely and voluntarily. Find those counts true. Again, find that there was sufficient evidence to find counts 2 and 3 true and find those true. I'm going to find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that.
This ruling shows the courtroom's most powerful weapon isn't the gavel, it's discretion. The judge chose reform over retribution, giving Mays a path forward. But it's razor thin. He's under stricter rules now than ever before. This is probation on a tightrope, and any wobble could mean prison.
I'm going to continue you on probation. I'm going to add an additional 3 years to your probation. So you could have already been done, but instead you have 3 more years. And that's the 1 year for every time that you've been an absconder. So that's what you're going to have to do at this point. I'm going to order that you enter and successfully complete the cognitive track of the ISF program. You need to take advantage of that program, learn to follow the rules, all the rules, get out, and you still have an excellent opportunity. But if you're back in front of me again, I'll see all of this. I'll probably wonder at the time what I was thinking today, but you will not get this opportunity again. Do you understand? 1 missed meeting. We're not going to do 2 or 3 missed meetings. We're not going to get to absconder status again. You miss a meeting, I want to hear about it in an administrative hearing. There's going to be a motion to revoke, and you're going to go to jail.
Your Honor, since he's going to cognitive track on ISF, could we rescind the moral recognition therapy? It seemed to be redundant.
Nope. Kind of seems like he needs some redundancy. Might help if he gets out and then has more to reinforce what he learns. So no, I'm not going to do that. All right, I'm handing you the trial court certification that shows this was not an agreement. You do have some rights to appeal. You can talk to Mr. Kimler about that. Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
What a case! Mays dodged prison, but barely. Misreporting, failed programs, last-minute efforts, all stacked up. Yet the judge saw a flicker of potential. This is what courtroom justice looks like when it balances mercy with accountability. If this breakdown kept you hooked, smash that like button. Drop a comment. Would you have let Mays go? Subscribe for more explosive courtroom breakdowns where every decision has a consequence.